So yes, the distinction between HLA Hart and the previous philosopher John Austin is essentially this: that when a gunman, okay, accosts you, okay, points a gun at your head, okay, asks you to hand over the money, you are being obliged, okay, you are compelled to hand over the money. You do not think that, okay, you ought to hand over the money, okay. Obviously not morally, but even otherwise, you do not think that you ought to hand over the money. You just do not have the choice, because if you do not hand over the money, you will be shot at and you will die, or maybe you will get injured. So to avoid that sanction, you hand over the money. Would this be a case of law? And then a state imposes taxes on you, okay, asks you to hand over your money. And if you do not, then there will be certain legal consequences, okay, maybe some kind of fine, penalty, imprisonment, whatever, okay, it imposes. But then you do not say, okay, you do not, even in those cases, okay, you do not equate the case of tax being imposed on you by the state with that of robber, okay. Now what is the distinction here? HLA Hart would say that whereas in the case of robber there is no tacit acceptance of that command to hand over the money, okay, whereas in the case of state imposing some taxes upon you, even though you disagree about what the amount of tax has been imposed on you, you still believe that because the law exists, I ought to hand over the money. So that's the ought that he's referring to. But the problem here is there are those amongst us, okay, who might think that, okay, the tax which has been imposed on me is in fact a case of robbery, okay, it's exorbitant, okay, I'm being enslaved, okay. What about that then? Is that not a moral argument? Okay, if that is a moral argument, why would the other case in which, okay, one says that, okay, even though the tax is not in accordance with what I want, okay, but still I ought to pay the tax, okay, why is this argument not a moral argument? The HLA Hart says that this is not a moral argument, okay. Now why he says so, let's look at it. So yes, that's what the idea is, okay. Now so he explains this idea of obligation, okay. So in the former case, in the case where gun is pointed at your head, you were obliged, okay, you just didn't have a choice, okay. In the later case, you have an obligation, although in this case you do not have a choice, but you still think that, okay, I ought to pay tax, okay. That's the distinction that he draws, okay. Now this is something that he explains, okay, with a very important example, okay. This example is given in the readings that I have shared with you, okay. So suppose, okay, it's a very interesting example. Suppose a Martian, okay, visits Earth, okay, and its spacecraft is hovering, somewhere like maybe a few hundred kilometers above the surface of the Earth, okay, and it zooms in on a traffic intersection, okay, and then what it observes is that people come somewhere, they stop, and then they move, okay. They observe this from far away, and then they see some kind of regularities in the behavior of humans, okay. So there is something going on there, okay. As an external observer, this is what you are observing. Then imagine the Martian spaceship descending a little bit. I'm just changing the story a little bit so that it's understandable clearly. Then they notice that, okay, when the light turns red, the people stop, okay. When the light turns green, they move. So now they see that, okay, yeah, for them, when the light is green, they think that they can go, okay. Now imagine a person who's sitting in the car, okay, and then they see the light as red, okay. Now there's a difference between how the person who is in the car is perceiving the situation and the Martians who are in their spacecraft, okay. The situation is this, that here when you are in the car, okay, you think that, okay, when the light is red, okay, I ought to stop, okay. Whereas to the Martian, it's merely an observation of regularity, okay. Now this is the internal aspect, okay. You think that when the light is red, you think that you ought to stop, okay. Now you might say, sir, there are many people who jump the red light, okay, when someone is not looking at them, okay, when someone is not observing them. So when the strong arms of law is not able to have a grip on them, they just escape the law. So in those cases, will there be no law? HLA Hart would say that no, just because someone has been able to predict perfectly and then escape the grip of law does not mean that there is no law. This is something that I explained in greater detail in the previous video, so kindly watch that. Okay, so you would say that what makes it law even when someone for example escapes the law? It's the obligation. So even when a judge adjudicates, okay, when a person who escapes, who does not follow the law, okay, we say that, okay, you ought to have followed it, okay, but if we were a fact positivist, we will not be able to make such statements. So the ideas of rights, okay, duty do not have much meaning for a fact positivist as it will have in the case of a normative positivist like that of HLA Hart. So yes, even when the judges adjudicate, they believe that they ought to adjudicate in a certain way. Okay, so that ought is what has been, captured by our philosophers here through this example, that when you are in the car, or when you are the police officer, or when you are the judge who's adjudicating, okay, there's a way that you perceive about the rules, okay, the obligations that it creates. You think that you ought to do it even when you might disagree with its content, okay. And that's the internal aspect of law, as HLA Hart is talking about. Okay, so yes, so that's essentially the idea of internal aspect of law. So is it clear to you guys so far? Have I been able to make sense?
Yes, sir.
Huh? I hope I did. Okay, but if otherwise, go and read the readings, okay, and watch the other video as well. Okay, that will help clear out some of the problems that you have. I try to relate this position of fact positivist with the critique that has been raised by legal realists, and HLA Hart's position is also an answer to legal realist criticism of legal positivism. So kindly watch that video as well, and I will address this question again when we take up legal realism. So yes, that's essentially the idea. Okay, so yes, when we talk about rules, then okay, so there's a way that rules are different from something, okay, things that are not rules. Okay, so yes, when rules are created, okay, when there are rules, okay, they create some kind of obligation, okay, and they are different from other kind of rules that might exist. Okay, so these rules that we are talking about, they are also supported by some kind of social pressure. Okay, so it could be because of tradition, or it could be the practice, whatever it is. Okay, when rules exist, they create a kind of social pressure. Okay, and that social pressure is very important, very necessary to maintain order in the society. Okay, now these rules that he talks about, which creates obligation, okay, they are of two different types. Okay, so for Hart, remember, there are two different broad kinds of rules. Okay, one is primary rules and the other one is secondary rules. Okay, so yes, what are they? Okay, so yeah, rules. So primary rules are very clear. Okay, primary rules create rights, okay, and impose liabilities and duties. As simple as that. Okay, primary rules creates rights, okay, and imposes duties. Okay, so for example, when it says that you shall pay tax, okay, of certain amount, okay, by certain date, by certain deadline, okay, it imposes a duty on you to pay your tax. Okay, so this is a primary rule. Okay, so I hope this is clear. Okay, these are case of primary rules. Okay, so primary rules essentially create either rights, or it creates, or it imposes duties. Okay, so yes, primary rules play a particular function. Okay, it regulates human behavior. It tells you what you can or cannot do. Okay, primary rules regulate human behavior. It tells you what you can or cannot do. Now, if you remember, I have told you that there is a kind of elitism in the idea of legal positivism as was conceived by our philosopher John Austin. Okay, he says that it exists only in political societies that have sovereign. Okay, now the beauty of HLA Hart's philosophy is that he says that these laws, okay, primary rules, okay, which are also laws, okay, can be possible, are there, okay, even in those societies in which we do not have the kind of political sovereign that our previous philosopher John Austin was talking about. Okay, so primary rules can be possible even even in those societies, okay, which are in kind of pre-legal condition. So the societies, okay, may possess rules, okay, they may possess rules, they may not have a legal system the way, for example, modern legal systems have, okay, but they may nonetheless possess certain rules, okay, and those can be considered as laws which are applicable to those people, okay. So it could be customary practices, they could nonetheless be laws, okay. So those are rules that tell you what you can or cannot do, okay. But the problem, there are certain problems with having only primary rules, okay. It's not sufficient, okay. There are certain things which have to be addressed, okay. The thing is that in a small society, you may know what you are allowed to, do, what you are prohibited from doing, what you are entitled to, okay. As you live in a larger society, like the way we have today, okay, even those primary rules will be unclear and uncertain, okay. So you need some kind of certainty about what these rules are and what their scopes are, okay. So primary rules, so that's the uncertainty is the first problem with having only primary rules, okay. And secondly, it's this, that, okay, primary rules do not change, and societies change and societies evolve, okay, and primary rules do not on their own change, okay. Now if you are living in small society, okay, and there is a primary rule, it is there and it becomes obsolete when the society changes, okay, and then the primary rules can then catch up with those changes in the society. However, in the larger societies that we live in, okay, you cannot rely only on those spontaneous changes in rules, okay. You have to rely on something more than just that, okay. So that's the problem with having merely primary rules, okay. They are quite often static and are inefficient because there is no authoritative arbiters of disputes, okay. So these things have to be resolved, okay. So your primary rules could be uncertain, it could be static, and there is no way for us to tell what constitutes primary rules in a larger legal systems, okay, like the way we have here, okay. So that problem of having only primary rules have to be addressed, okay. And to address that, okay, you have something called secondary rules, okay. There are secondary rules, okay. So HLA Hart says that there are primary rules and then you have something called secondary rules, okay. Primary rules regulate human behavior. They tell you what your entitlements, what your rights and what your duties are, okay. Now secondary rules are of essentially three different kind, okay. So what are those, okay? There is a secondary rule of recognition, there is a rule of change or amendment, and then you have rule of adjudication, okay. So the rule of recognition stands higher among the secondary rules that HLA Hart is talking about. Why is that? Because all other rules, whether they are rules or not, be it primary or secondary, will ultimately be traced from the rule of recognition. It will be the rule of recognition in a particular legal system that will tell you whether the rules are valid or not valid, okay. So yes, rule of recognition is also a secondary rule, but it's higher in importance than the other two kinds of rules that we will look at, okay. But then they are related, as you will see, okay. I say it's higher only because for the purpose of cognition here, okay. So apart from the rule of recognition, there is also a rule of change and amendment. So I told you that if a society that has only primary rules, okay, the rules are quite static and are not able to keep up with the societal changes. So in a modern legal system, you need some mechanism out there that will also, make provisions for that. So you may have, powers laid down in a constitution, okay, as to how to change and make amendments to the existing rules, okay. So that's there. And then you also need a neutral arbiter, okay, to adjudicate the matter, okay. In a small society, if you're part of a small community, yeah, matters are probably dealt with, okay, adjudicated by elders of the community, okay. But if you are living in a huge legal system like ours, then you need some neutral arbiter to decide the matter. So these are the problems with having only primary rules. So you need secondary rules, and there are three broad kinds of secondary rules. One is rule of recognition, the other one is rule of change or amendment, and the third one is rule of adjudication. Okay. Now, out of these two, the rule of recognition is very important. Okay, I told you rule of recognition essentially recognizes what other rules constitute valid rules. Okay, so they identify, clarify, and qualify primary rules. Okay, and rule of recognition provide you something called what is known as publicly ascertainable rules, that I need to know the rules that are binding on me. Okay, so the rules have to be publicly ascertainable, and that's the function that rule of recognition plays. Okay, now where do you find the rule of recognition? Okay, you find the primary rules in the law books. Okay, it creates obligations. Okay, but then there are also other rules. Okay, so in the constitution you might find provisions provide how to make change, how to amend the law, how to create new law. It provides that. It might also make arrangements for judiciary that will adjudicate the matter. Okay, fine, but where the hell do we find the rule of recognition? Okay, so that's where the problem is. Now, before I address that question, one more difference that I would like to address now, because I think in the next semester that will be essential. So whereas primary rules talk in terms of rights and liabilities, rights and responsibilities, duties, secondary rules, are power conferring rules, So secondary rules confer upon you the power to make changes in the primary rules, So make change. So essentially, it confers powers on you to make new rights and then impose new responsibilities, duties. So for example, if you have the power to transfer your property, when you transfer the property, new rights and duties are created. So this power that you have, we do not use the word merely right, because right in the Hohelian sense means something very restricted. Broadly you may use the word right, I have the right to sell, but more specifically it's the power. Now that's not merely case of thou shalt do this or thou shalt not do this. It's much more than that. So yes, here in Hart's case, the rule of recognition are power conferring rules. They give power to the officials to those upon whom the powers are conferred to bring about changes in legal relations. So yes, out of these secondary rules that we discussed, the rule of recognition is very important. It helps you in identifying, clarifying, and qualifying the primary rules. It provides you publicly ascertainable rules. We all know what the rule is. Now the problem is, as opposed to the other rules, it's difficult to identify the rule of recognition. Where do we find it? Now you won't find the rule of recognition written anywhere in the book. It's a fact that you have to observe. It's a fact that you have to observe. What's that fact then? It's an empirical reality. Whether the rule has been accepted by officials. Now whosoever these officials are, because we do not have a rule that determines who these officials are yet. But then we are saying that rule of recognition is what is accepted by the officials. Now this is something that HLA Hart has to address. But if rule of recognition is what officials accept as rule of recognition, then where is the rule that recognizes officiality of the officials? That's the problem that HLA Hart does not clearly address. But we'll deal with this. Now the problem is, and here's the thing. Now there is an external and internal aspect to both these things. So if you are observing, what the official is doing, you are like that Martian who's observing certain regularities at the traffic intersection. But when the officials are observing the rule of recognition, they think that they are bound, they are obliged by that rule. So this is the important aspect. So rule of recognition for an outside observer is an external reality. It's a observable regularity. So you may say that this is what this is how the officials behave. So for a bad person, I gave you the example in the previous class, okay? For a bad person, okay, the idea here is that he will have a, external, okay, view of the whole thing, okay? But for the official, okay, who think that, okay, they are to apply the law in this way, okay? They think that, okay, we ought to, behave in this way, okay? This is what we ought to do, okay? So even in rule of recognition, to the outside observer it will be an externality, external, regularity, and to those officials it will be something that is internal, okay? They would say that, okay, this is what, I ought to do, because this is what the law is, okay? So yes, that's the idea, okay? So the external aspect is what is the empirical reality, okay? But the internal aspect is what the officials themselves feel, okay? That they ought to behave in a certain way, okay? They ought to enforce the law in a certain way, okay? So now the question of legal validity arises, okay? How do we know whether the law is valid or not, okay? HLA Hart would say that whether the law has been recognized under the rule of recognition or not, okay? So how do I know whether it has been recognized or not? Then you have to observe as an outsider whether, okay, this is something that is enforced and applied by the officials regularly or not, okay? But then if you are the official, you will have an internal aspect that, okay, this is something that I ought to follow and ought to recognize, okay? So that's the internal aspect, okay? So I hope this is clear. Was I able to make sense so far?
Sir, can you please repeat the last point about the validity of the law? I couldn't hear.
Yes, I'll come to that. So whether the law is valid or not will depend on whether the rule is accepted, okay? Rule is recognized under the rule of recognition or not, okay? If it is, then obviously, okay, so whether the state law is law or not, whether the officials apply the law or not, okay? So from that empirical reality, you can say that yes, it is the law, okay? Now, whether the law is valid or not will not depend on, you and I, okay, the, others, okay, on our subjective perception as to whether the law ought to be followed or not, okay? Because if HLA Hart says so, then it is not a case of separation of law and morality. So even when you disagree about whether the law is moral or not, okay, if it is a law which is recognized by the officials, okay, under the rule of recognition, then it is valid law, no matter how morally, egregious it is, okay. But for the officials, okay, when they apply the law, when they, recognize their, law under the rule of recognition, they feel that they ought to recognize it, okay. So even for the officials, they have an internal aspect, okay. Even in that case, HLA Hart says that ought, okay, that obligation that the officials consider themselves as having, okay, that is not a moral ought. That is just another, internal aspect, okay, that internal point of view that HLA Hart was talking about that we discussed a little while ago, okay. So you might come across officials, even they might think that, okay, the law seems to be problematic, morally not acceptable, but they think that, okay, but I ought to apply it nonetheless, okay, because this is the law, okay. If most of the officials are generally, okay, applying it like that, then you can say that, okay, from the empirical reality, I can come to this conclusion that, yes, the law is valid, okay. But if it is not at all, okay, followed by the officials, okay, not the individuals, but by the officials, then that's where the problem is, okay. So that's when you can say that the law does not exist, okay. Now the problem is that how do officials come to that conclusion that, okay, we ought not to follow the law? You will see that quite often the moral considerations will be there, okay. Moral reasons will be there for officials to follow or not follow the, not recognize something as a law, okay. If that's the case, in other cases when the officials say that, okay, it ought to be followed, okay, even when I morally disagree, why is that not a moral reasoning is a question that I raised earlier as well, okay. So if you go back to Thomas Aquinas, even he had said that you might come across, laws which are unjust, but you might have a moral obligation to, observe the law nonetheless. Why does he say so? Because not observing that specific, case of unjust law might lead to collapse of the entire legal order. And you do not want that to happen. And that's a very much moral reasoning, isn't it? So in this case as well, I see that, yeah, why is rule of recognition not a moral rule, and why is it merely a social fact? Okay, yes, obviously, to an outside observer, it seems to be a case of irregularity, so it's a case of certain fact as well. But then, if you look at it from the internal aspect, point of view of the officials, why is it not a case of moral ought? HLA Hart would simply say this: even when some of the officials think that the law is not morally in accordance with what they think, is morally correct law, okay, they nonetheless feel that it ought to be followed, okay. So yes, that's the internal aspect. That's the normativity of the law, okay. That's the rule of recognition that HLA Hart is talking about. So yes, I can get this a little more complicated, but yeah, this should suffice. And if you want to, then yeah, you can get into conversation with me. Now he says that you now have something called primary rules, okay, that create obligations, okay, regulate human behavior, and then you have secondary rules. You have rule of recognition at the highest rung, okay, recognizes all other rules. Then you have rule of adjudication and amendment or change, okay. So yes, these are rules, okay, and primitive societies, they had only primary rules, okay. Now the legal system that we have today, okay. When do we have a legal system? When we have a legal system when we have a union of primary rules with that of secondary rules. So you can call a system as legal system when there are primary rules, but they are also there along with the secondary rules. So secondary rules will recognize what the primary rules are. Secondary rules will help in arbitrating the meaning of what the primary rules are. It will also help in changing or amending the primary rules. Okay. So union of rules creating duties and rules creating powers to create, extinguish, modify, and adjust, as well as rule of recognition with which to identify primary rules. Okay. Together they become what we know as rule of recognition. Now I think we are way past the time that we are allotted for today. So I'll stop it for today. In the next class, hopefully I should be able to complete HLA Hart.